You're listening to The Liberty Beat, your daily source for liberty news and activist updates. Online at thelibertybeat.com. John Bush here with your Liberty Beat for February 8th, 2013. Gold opened today at $1,677. Silver at $31.76. And Bitcoin is trading at $22.39. Today's edition of the Liberty Beat is sponsored in part by Central Texas Gunworks, offering firearms training courses, concealed carry classes, and firearm sales. Online at centraltexasgunworks.com. And now the news. A former Los Angeles cop with military training vowed war against other men in blue Thursday, leaving one officer dead days after he allegedly killed two other people to begin a wave of retribution for being fired, police said. The focus of the intensive, expansive manhunt is Christopher Jordan Dorner, a 270-pound former Navy lieutenant who has professed his venom against LAPD officers he claimed ruined his life by forcing him out of his dream job. Dorner blames one retired officer for bungling his appeal to get his job back in an 11-page manifesto in which he has also complained of mistreatment by the LAPD. In that letter, he vowed to violently target police officers and their families, whoever and wherever they are. The chairman of a Senate committee recessed John Brennan's CIA confirmation hearings and cleared the room after protesters persistently interrupted the proceedings.
Speak for the mothers.
All right.
Children.
We will stop again.
In Yemen,
all right.
Pakistan, Somalia, and who else? Where else?
Please remove that
CIA and the Obama administration refuse to even tell Congress.
Police removed several protesters at the beginning of the hearing on Thursday. More began yelling after Brannon began testifying, and Intelligence Committee Chairman Dianne Feinstein ordered the hearing recessed while the room was cleared. The protesters were shouting objections to lethal U.S. drone strikes and harsh interrogation methods. A severe winter storm is barreling towards some of the most heavily populated parts of the country today, closing thousands of schools, causing massive travel disruption, and threatening to bring more than 2 feet of snow and gale-force winds to much of the Northeast. The National Weather Service issued blizzard warnings from North New Jersey, northeast to Maine, and with New York and Boston expecting to be among the hardest hit. Airlines canceled more than 2,400 flights across the region as the storm barreled eastward from the Midwest and Great Lakes, according to FlightAware.com. The Liberty Beat is sponsored by Parents for Liberty, bringing the philosophy of liberty to parenting and parenting to the philosophy of liberty. Online at parentsforliberty.org, and by Brave New Books, specializing in free-thinking material for free people since 2006. Online at bravenewbookstore.com.
Okay, this is Randy Kelton here with without Deborah or Eddie. This is our Friday night 4-hour info marathon. It is Friday, February the 8th, 2013. I don't have any guests tonight, and I do have something I want to talk about. It's something that I'm working on. You folks have probably got tired of hearing me talk about bringing up bar grievance and judicial conduct and all of these other tools that I'm working on, and I can understand that because from my end it's been extremely frustrating. But I also talked about how an engineer does what he does, and a good engineer doesn't really design the project. He tries to keep himself out of the way and let the project design itself. Well, this project has designed itself, and we're putting together some final pieces. I'm running into a few little glitches here, but we have a set of tools that's coming together where we can take most any code, and about all of them are on the web in one incantation or another. download them off the web, run 2 or 3 routines on them, and get them structured to where we can walk right down through these and convert the codes from statements to questions. And the questionnaire aspect, I've talked about that before, and how well that works. And in using it and watching other people use it, it became clear that this is going to be a very effective strategy. One of the things that I finally realized in using the questionnaire this way is the bar grievance, for instance. The way bar grievance, the American Bar Association model standards are structured with generally 4, maybe 5 questions, I can bring you to any particular grievance. And the thing that dawned on me about that is when I do research, I look through the codes and look for the information that I need. But always there is this nagging notion that since I'm not learned counsel and I didn't spend 4 to 6 years in some structured learning environment where you're given all of the essentials, I'm always worried that something's missing. That in my repertoire or in my learning all the things that I've learned over this time, there are these huge holes, and I'm always afraid I'm going to fall through one of them. But when you follow a questionnaire like this, they tend to point very clearly in a direction. And when you get to the end of one of these, you don't have that nagging feeling that you might need to go read this whole code because there's probably something else you've missed. Or there may be other things in there you've missed, but this is the one that's on point because your answers led you to this point. It makes it relatively easy to mine these codes, find the information that you need without missing anything. The only thing you miss is what we haven't programmed in yet. Every time we come across an eventuality that we don't have a question to address, we just look down the code and see where that question should be dropped in. We drop the question in, and the system never forgets to ask the question of everybody who winds up passing that point in the questionnaire. Because, frankly, the questionnaires are huge. But nobody sees all of those. They just see the part that's appropriate to them. So we have developed a technology for this that is going to make the development of these codes far easier than we expected. And if any of you have went to Remedies in Real Estate lately and clicked on the free forensic analysis, you'll get a look at another prototype. That one is not near what it will be, but it gives you the idea of what we're doing. What you'll be looking at there is essentially a simple mind map. Not such a simple mind map, but the mind map that you're looking at looks like the file system on my server. And the file system on my server looks exactly like the file system on my desktop computer that I use to set up the server with. And we have some tools that when we put forms in there that have input in them, they will create tables and fields in a database, and the database schema, the structure of the database, will look just like that file structure. And that's one of the pieces that we've developed to make this more understandable. Makes it much easier to work, much simpler to develop. The main thing is that mind map. The mind map is a way of looking at all the information at one time, all the information that's generally relative. We're going to make some adjustments to how that works, because that mind map that you're looking at, although it has a tremendous amount of information in it, and I loaded about 2,000 more files in it today. Frankly, I crashed it. A minor little error. We take care of that. We'll figure that one out. We keep running into these little unexpected bumps. But we will have very soon about everything you could imagine concerning the mortgage issue. We're building a structure so that when we come across new information, we can open this map and look at it and say, this piece of information is relative to these issues over here, and it should go in this file, in this folder. So logically, when we're looking at this issue, we'll be looking in this direction and we'll find that thing. And over all the time that I've been doing all this research, that has been the biggest problem, is keeping information in a way that you can find it. And that's been a struggle for people ever since we've started putting together these big computers. People have struggled with a way to organize the information so you're able to find it. And it appears that human beings are visual. So we're creating a tool where you can see it. But what you're looking at there, when you look at the forensic analysis, is just one aspect of the entire body of law. And it's really not part of the law. The law is separate from that. This is like... this is outside the law looking in. And we've tried to structure tools so we get a clear view, but one of the tools we don't have is we don't have the entire corpus juris incorporated into a similar map like these are, or this one. We also have one that we'll be bringing up for criminal. Traffic, of course, that Eddie's working on. And we'll do family and all these most common issues people have first. We'll build something similar to this, a repository of information that's structured in a way that human beings can make sense of it. Structured in a way so that when an issue arises, we have the law and the structures in place so you can look at that issue and see what's relevant to the issue. Anybody here who's tried to figure out a legal issue, especially if you're not a lawyer, the biggest problem is not the details. It's knowing where to look. And it appears, though, this map is going to give us a way to look. And speaking of looking, I just looked at the caller board, and it's stacked up already. So, since we have so many callers, I will stop blabbing about this for the time being. But if you get a chance, go to remediesinrealestate.com and click on the free mortgage analysis. Whether you have a mortgage issue or not, that's not the point. Look this over, and I need critical feedback. We're trying to develop a tool that's intuitive. And if it is effectively intuitive, you won't have places where you're stopped. You bump into something, you have no idea what the heck is going on. Anybody who's ever tried to teach themselves computers really understands this. The really, really simple stuff. The stuff that I learned 5 years ago, or 25, 30 years ago when I started researching. So simple, I don't even notice it anymore. but so critical that if someone who's not familiar with this comes up to that spot and they don't have this piece of information, they are stuck. I have worked on these programs and spent a week. Chomula, it's a tool for building websites. I got the book on it. Not one place in any of the information in the book, nowhere could I find how to load a file onto Chomula. That was so simple, and everybody knew how to do that who worked with it, but I didn't work with it, and it wasn't intuitive. I never did figure out how to load a file onto that website page, and finally just tossed it and went to something else. After I probably spent 3 weeks trying to figure that one out. And somebody could have come to me, and I knew that, and said, here, right here, just push this button, boom. But I didn't know how to push a button. Let me know if I've missed any buttons. Let me know if in going through this you bump into places that you're stuck or it doesn't make sense or one thing doesn't flow from the other. Rip me to pieces. This is my prototype. This is going to teach me how to build far more sophisticated structures, and we will wind up with our electronic lawyer. This is the first part of the electronic lawyer. We'll wind up eliminating the profession of lawyer and get the lawyers to pay us to do it. This is Randy Kelton, Deborah Stevens, Eddie Craig, Rule of Law Radio. Tyler, Mark, Marie, I see you there. We will go to the phones as soon as we come back on the other side. So calls are already starting, so give us a call, get in line. We'll make sure we get to everybody. We'll be right back.
All the talk about gun grabbing got you down? How would you like to be the proud owner of a brand new AR-15? Then go to LogosRadioNetwork.com and enter the drawing to win a free Rock River AR-15, sponsored by Zombie Killers Ammo and Guns. Support Logos Radio Network by donating just $20 to their fundraiser, and you'll get your name entered into the drawing. Second place prize is a Spikes Tactical AR-15 lower receiver, sponsored by CentralTexasGunworks.com. Every $20 you donate will put your name in the hat. So increase your chances of winning by increasing your donation. Winners must be eligible to lawfully own and possess these items. Please visit LogosRadioNetwork.com for details. If you love all the liberty-minded programming on Logos Radio Network, contribute to the fundraiser and secure your chance to win a Rock River AR-15, sponsored by Zombie Killers Ammo and Guns. Like them on Facebook at Zombie Killers LLC. Contest ends February 28th. Are you being harassed by debt collectors with phone calls, letters, or even lawsuits? Stop debt collectors now with the Michael Mirris Proven Method. Michael Mirris has won 6 cases in federal court against debt collectors, and now you can win too. You'll get step-by-step instructions in plain English on how to win in court using federal civil rights statutes, what to do when contacted by phone, mail, or court summons, how to answer letters and phone calls, how to get debt collectors out of your credit report, how to turn the financial tables on them and make them pay you to go away. The Michael Mirris Proven Method is the solution for how to stop debt collectors. Personal consultation is available as well. For more information, please visit ruleoflawradio.com and click on the blue Michael Mirris banner, or email michaelmirris@yahoo.com. That's ruleoflawradio.com, or email michaelmirras@yahoo.com to learn how to stop debt collectors now.
You are listening to the Logos Radio Network. LogosRadioNetwork.com.
Okay, we are back. Randy Kelton, Deborah Stevens, Eddie Craig, Rule of Law Radio, and we're going to go to Tyler in Wyoming. Hello, Tyler. What are you up to today?
Oh, I got about a couple, 3 things going on, Randy, so I wondered how much time I had on the air to be fair.
Well, you're kind of floating in and out there.
I wondered how much time I had on the air here because I got about 3 things going on.
Well, okay, we've only got 4 hours.
Okay.
Go ahead. We should have time.
I'll try to keep it brief. I know you got other.
If you get too long, we may take Mark and Marie and then come back to you if you're too long-winded.
Yeah, no problem.
Okay.
My first case, I got a licensing issue. I have a trade here in Wyoming, and they say that I need a city license for it, and I disagreed because I said, well, your city license is only lawfully, required on city property. And I said, well, it's a private property issue. It's a contract between me and the private property owner, so there's disagreement between me and the code officer. But you had mentioned a while back, and this is what I don't know, is how you come to this conclusion. It's an ordinance that they passed that you need a license for this trade. And you had said that ordinances were only for, I believe, city officials or public officials, but not for the private sector. Didn't know.
Yeah, this is Eddie's argument, and it's very well argued that the legislature was authorized by the Constitution to pass law. They were not authorized to delegate that power to anyone. So this municipality is a corporation. And this goes to Harmon Taylor's. What he talks about is this commerce issue. There's a lot of guys that bandy around the commerce issue, but most of that stuff I find not very useful. But the idea of offering acceptance. I live right next to City Hall, and I'm engaged in some contracts with them. I have to maintain my plumbing to their code because I'm attached to their system, and I contracted with them to use their plumbing, both incoming and outgoing. So in that regard, we're in a contract, but only for those utilities. I contracted with the electric company for electric and the gas company for gas. And as far as I'm concerned, the only thing that the municipality has anything to say about is my plumbing. Does that make sense?
Yeah, it does. My question is what this code officer told me. What I told him, first of all, he said first, he goes, if you really think that, then let me know where your next job is, and we can get this settled. And I said, well, it's none of your business where I work, And I do tree trimming. That's what I do. And there was a requirement added to the licensing that you had to be ISA. And that means International Society of Arboriculture. Well, the problem...
Wait, hold on. Where did the municipality get the power to interfere with private contract?
Well,
the state kind of got it, and we're not fighting that one. But now we have municipalities deciding to license professionals.
Well, absolutely, and not only that, but they make you be a part of a federal mandate because it's got a federal trademark called the International Society of Arboriculture, and they got their own set of rules and bylaws. So basically, and I already got that license. I know that material, but I just don't have time or money to keep up with that all the time, and I don't renew it like I should. But I know the skills, and I have insurance, and that's what I basically told this guy. I said I didn't quit, learning what I've learned, and it's just a technicality. And he said, well, no, it isn't. He goes, we'll shut you down or take you to jail if you're caught. I said, even on private property, between a contract between me and a private citizen, you can become a third party. He said, oh, yeah. He said, in fact, it's an illegal contract. I said, no, it isn't. I said, I can make a contract to do a service free work for anybody that wants to do that. So we have it's going to be a problem, is what I'm saying. There's going to be a conflict happen here eventually. And I want to know how to prepare to stop this, I guess. Do I need to register with county records a right-to-work statement? Or, how would you go about?
Well, that would probably be a better issue to take to the Monday night show. I could guess about it, but I haven't done the research on it, and Eddie has.
Okay. I do know it's contractual, but yet they can't force you to contract. And I have a couple Supreme Court cases that a friend had given me. You might look them up if you get time. I'll just give them to you real quick, Randy.
Better if you email them to me. There's no way I'll remember them.
No, that's okay. I'll email them to you. Second question real quick. Second thing I got going on, I got a warrant out, traffic, unjustified, of course. I went to court, and as a bogus ticket, I was actually the victim of an accident. The officer cited me because I had a stop sign. Well, I was already in the intersection, and the lady just didn't stop. Well, that's not my fault. And she signaled, and she decided not to signal and just decided to run into me. So, but the officer didn't see it, and he come out there and cited me, and I tried to explain, and he goes, well, you had the traffic advice. I'm like, well, that doesn't mean I wasn't wrong. But anyway, I fought it on the right to travel. And I gave the judge an affidavit on the right to travel. It was a special appearance. And I went to 4 different hearings because I kind of played the game. The first 2, I said, well, I can talk to an attorney. And I was just, trying to figure out the best strategy of law. And make a long story short, at the last hearing, I gave him the affidavit again. And he said, well, this is the municipal court, not the county court. He noticed another mistake in it, so he handed it back to me. And I said, well, I'll correct this, but I want to note it that I recorded it this day. And he goes, well, it's stamped. And I said, okay. I said, well, I'll make corrections and give you a corrected one. Well, I think that was a trick, because what he did, because that wasn't in his possession at that time, and then he said, but you owe the bond. And I said, Your Honor, well, that's discussed in the affidavit. I don't really owe the bond because, first of all, it's challenging the jurisdiction in the affidavit and talking about, you need to look at this first. And he said, well, and I told him there's no due process either, and that's against the Fifth Amendment to be deprived of that money, because that's my property. The Supreme Court said your money is your property. So I said, I'm being deprived of this money without due process. He goes, he didn't argue. He just said it again. Well, I told you need to pay the bond. And I said the same thing to the clerk at the window. I'm not going to pay the bond. The judge needs to go through the affidavit. Well, they did actually put the warrant out. And I did talk to Eddie briefly about this, and he had mentioned that I should motion the court for dismissal and maybe ask for a jury, but I didn't know what the dismissal would be on. The fact that he did not answer the affidavit, or I don't know how to proceed, or should I motion to quash the warrant? I didn't know which to do.
I'm not sure even the way to get rid of the warrant is just walk up in front of the judge, and then the warrant goes away. What the warrant has to say is arrest this person and bring him before me. Well, you're already before him. So the warrant becomes a moot issue. Now, if he's going to...
a time for traffic court and show up, or, how do you do that?
Okay, is this for a failure to appear or for not posting a bond?
It's not posting a bond, yeah.
And why did he set the bond?
I don't know. They didn't used to do that here. And it used to be if you lost, you just paid it.
Well,
now they're making you pay for the amount of the citation as a bond. And their excuse is, so we guarantee our money, so if you don't show up for court, we didn't waste our time getting everybody here. That's their excuse.
Oh.
And then we just keep the money.
Well, okay, wait. Now I think I'm missing part of this. This is an appearance bond, and he revoked your personal recognizance bond. That's what I was getting at. Why did he do that?
Basically, it's guaranteeing that I'm going to show up.
I know what the bond is. Hold on. We'll be right back on the other side. This is Randy Kelton, Deborah Stevens, Eddie Craig. Real Law Radio. We'll be right back.
A Virginia company has brainstormed a new idea to house aging relatives, a prefab cottage that fits in the backyard of a family's home. I'm Dr. Catherine Albrecht, back to tell you about a great idea called Granny Pods in a moment.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This message is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
For the elderly, moving into a nursing home can be devastating. But now a Virginia company is offering an alternative, compact, high-tech cottages that fit in relatives' backyards. The company N2 Care says its Granny Pods are selling like hotcakes. These 280-square-foot cottages have everything a hospital room does: safety rails, lighted flooring, a defibrillator machine, and electronics that monitor vital signs. The pods can cost up to $125,000, and you have to get local zoning approval. But for elderly folks who want to keep family in their lives and still maintain their personal dignity, these prefab homes seem pretty fab to me. I'm Dr. Catherine Albrecht for StartPage.com, the world's most private search engine.
This is Building 7, a 47-story skyscraper that fell on the afternoon of September 11th.
The government says that fire brought it down. However, 1,500 architects and engineers concluded it was a controlled demolition.
Over 6,000 of my fellow service members have given their lives.
And thousands of my fellow first responders are dying.
I'm not a conspiracy theorist.
I'm a structural engineer.
I'm a New York City correction officer.
I'm an Air Force pilot.
I'm a father who lost his son.
We're Americans, and we deserve the truth.
Go to rememberbuilding7.org today.
And now we have sheriffs saying, you're not going to do that here. We don't care what laws you pass. You want to play with those little things in Washington, D.C., that's fine. But you're not doing it in my county. As long as I'm the sheriff here, we will draw the line in the sand, and we draw the line with freedom.
Join Sheriff Mack for 2 special free engagements in Austin this week as he encourages you and local law enforcement to stand up to the federal bullies aiming to take away our rights. Sheriff Mack will be speaking this Friday at Hills Cafe, 4700 South Congress Avenue at 7 p.m. And on Saturday at 7 p.m., he will be speaking at your favorite local Liberty bookstore, Brave New Books, located at 1904 Guadalupe. For more information, please call the bookstore at 512-480-2503. And remember always, Austin, be brave.
You're listening to the Logos Radio Network at logosradionetwork.com.
Yeah, I got a warrant, and I'm gonna serve them to the head government, them prosecute them. Okay.
Okay, we are back. Randy Kelton, Deborah Stevens, Eddie Craig, Real Law Radio, and we're talking to Tyler in Wyoming. I know what the bond is for. My question was, since it's a traffic ticket, you were released on your personal recognizance.
Right.
How did he did he make an adjudication in the case?
Well, this is what was strange. See, I had at all 4 of these hearings.
No, wait. Don't go into a long explanation. Did he make a ruling in the case?
No, not at all.
Okay, so the case is still open.
Right.
Oh, okay. If he had made a ruling, there's no way he could ask for a bond.
He was setting it for trial, but he wanted me to post a bond for that trial to make sure I appeared there in the trial. So he punished you for electing to defend yourself. Basically, yes.
That's in the case law, that they can't punish you for exercising your rights. That's one of the due process claim you should make against him. Had you always showed up for hearings?
Yeah, I showed up for all 4. Yeah.
That he had no reason to revoke your personal recognizance bond. Okay, that you should go after him for that, for retaliation.
Now, how do I do that though? What do I file? This is what I don't know, Eddie.
Motion, file criminal charges against him. Official oppression. He retaliated against you by forcing you to pay more than the ticket just to be able to prove your innocence.
Okay, so file an official oppression. Now, is that a judicial complaint or?
No, that's a criminal complaint.
Okay.
He wants to play criminal, you play criminal. Go down, do your little dance with the prosecutor. Best defense is a good, effective offense.
Now, this is a stupid question, but we don't have prosecutors for these traffic trials here. So do I?
Okay, always a complaint against a public official goes to the district attorney.
Okay.
And you don't want that chump prosecutor in this judge's court even looking at your complaint. This is the whole deal about creating a little political pressure. Is you go to somebody over whom the judge has no control, and you start kicking them around because they don't go after the judge. And you get them all PO'd at the judge and get a little pressure to make this thing go away, so you stop filing criminal charges against everybody.
I got you. Now, the official oppression would be because of the Fifth Amendment. It's the denial of the due process, right? He's making me pay the amount of the ticket before I've even gone through due process.
Right. He's punished you for exercising your right.
Right.
And he stated it for that reason. Since the only reason he did that is because you demanded trial.
Exactly.
So go after him for that. Get him to do some explaining.
Now, I'm not trying to sound negative, but let's just say that the district attorney just ignores it. Well, what's my remedy in that case?
Have you not been listening to this show?
Not enough, probably.
Obviously not. You hope the district attorney ignores it.
Right. I've heard you say that, but then...
When he ignores it, then you go to the district judge.
Okay.
And then you do this by certified mail. Don't let them see you.
Right.
Make up a verified criminal affidavit accusing the prosecuting attorney of shielding this judge from prosecution by exercising caprice instead of prosecutorial discretion and refusing to pursue prosecution with a grand jury against him. Do you have grand juries in Wyoming?
Yeah.
Good. By refusing to present your complaint against the judge to a grand jury. And you give that to a district judge, and the district judge is most likely going to send it back to you and tell you need to file that with a police agency. And then you file with the police agency a criminal complaint against the district judge for not performing his duty as a magistrate. And then you file a criminal complaint against the district judge, because all you file with the policing agency is a voluntary statement. You make up a criminal complaint and send it to the grand jury, foreman of the grand jury, registered restricted, and you accuse the district judge of official oppression by misfeasance in office, in that he failed to perform his magisterial duty for the purpose of shielding the prosecutor from prosecution. And you send that to the foreman so that when the prosecutor intercepts it, he is very, very badly compromised.
Okay. Now, could you repeat that, Randy? What do I file on the district judge?
Official oppression or official misconduct, depending on what the name of the statute is in Wyoming. You accuse the judge of failing to perform a duty he is required to perform. and in the process denying you the full and free access to or enjoyment of a right. And you did it for the purpose of shielding the prosecutor from prosecution. In Texas, that's a felony.
Or shielding the prosecutor.
Yeah. Look for shielding from prosecution or obstruction of justice. Now, excuse me. Now, with that said, when you do this, you can expect some smart-mouthed, jack-leg police officer in the form of a bailiff to give you some sage advice and warn you about all those bad things that can happen to you for you doing this kind of stuff.
Yeah.
You hope they do.
Okay.
We just had someone, he got a warranty deed to a property and stopped foreclosure on it. He moved into the property, and a woman changed her mind, and she was an ex-police officer, came into the property with her gun in her hand. Fortunately, he wasn't there. And then called the police, and they came in and stole a bunch of his stuff. So, took his car, took personal files out of his house. And I was working with him on how to handle this, and he called down to the police department and talked to a sergeant there. And the sergeant told him all this was a bunch of nonsense, and he could that him having a warranty deed, that he had to go through a title company in order for her to transfer the property. Sergeant had no idea what he was talking about, and that he could look for criminal charges to be filed against him. I couldn't believe he said something so stupid. So I just helped him prepare today criminal charges 3605 Penal Code, witness tampering, that he threatened Daryl with the criminal prosecution in order to prevent Daryl from performing his duty as a citizen and give witness to criminal acts by fellow police officers. This guy's really a bonehead. So he can't go to the police department with his complaints. Heck, they might shoot him. So he's going to send the criminal complaints to the mayor. But I told him, don't give the mayor any legal advice. You're not his lawyer. He's got one down there. Right. And the lawyer is going to tell him, well, he should file that with a policing agency. They'll probably send it to the county sheriff.
Right.
And then we'll file criminal charges against the mayor because he's a magistrate. They're going to get real excited. This creates a lot of politics.
Yeah, it is politics, and I've learned that from your show. The thing is, when I went to the district attorney's office one time, because I tried to file a complaint that a sheriff wouldn't handle, what they said was, now I'll send this from receipt, okay, I won't go in, but they said that go down to the sheriff's office and complain. We don't take complaints directly. So how do you get around that?
Then he breached the code. He misfeasance in office, failed to perform a duty he's required to perform. You file against him. Okay, hang on. This is Randy Kelton, Deborah Stevens, Eddie Craig, Rule of Law Radio. Our call-in number, 512-646-1984. We'll be
Mr. President, members of Congress, you've been making a lot of noise about taking our guns away. But you might want to review history. 1835, Gonzales, Texas Territory. The authorities wanted to confiscate the big gun that protected that colony. You know what the people said? Come and take it. Because they were willing to fight for their freedom and their guns. So are we.
Come and take it if you want it. Come and take it if you think you can. Come and take it, but I warn you, you'll have to pry it from my cold dead hands. We want the freedom that God gave us, so you best not cross that line. If you want this gun, you gotta come through us and take it.
One shot at a time. Just like Gonzalez, we're keeping our guns.
Are you the plaintiff or defendant in a lawsuit? Win your case without an attorney with Jurisdictionary, the affordable, easy-to-understand 4-CD course that will show you how in 24 hours, step by step. If you have a lawyer, know what your lawyer should be doing. If you don't have a lawyer, know what you should do for yourself. Thousands have won with our step-by-step course, and now you can too. Jurisdictionary was created by a licensed attorney with 22 years of case-winning experience. Even if you're not in a lawsuit, you can learn what everyone should understand about the principles and practices that control our American courts. You'll receive our audio classroom, video seminar, tutorials, forms for civil cases, pro se tactics, and much more. Please visit ruleoflawradio.com and click on the banner or call toll-free 866-LAW-EASY.
Okay, we are back. Randy Kelton, Deborah Stevens, Eddie Craig, Rule of Law Radio. And we're talking to Tyler in Wyoming. And, yeah, we hope that the prosecutor tells us something like that. I love it when they do that. Okay. Oh, you need to follow this with the police department. Recently, I had a justice of the peace refuse to let me see some records. And I asked the bailiff to arrest the JP. And he said that if I created a disturbance, he'd arrest me. So I asked him if he was threatening me. He started to say something else. And I asked him again. I cut him off and said, "Are you threatening me?" Oh no, Mr. Kelton. I just calm down. Oh, I'm calm. Now, if you're not threatening me, arrest her. Oh, well, Mr. Kelton, I have to administer the court. I'll get you a constable. So it takes me down to the constables. Constable refused. So, he's saying that we don't do that. I don't care what you do. Yeah, that's what well, we have a policy. I don't care about your policy. You are a certified police officer, are you not? I said, well, yes, I am. Then go arrest her. No, we don't do that. So, you're refusing to perform your duty as a peace officer. Is that what I'm to understand? Well, if you put it that way, yes, I guess I am. Oh, okay. Thank you. I think I'm done with you. I turned and walked out. He's standing there scratching his head. So I go across the street to the sheriff. They had a sheriff's station over there. That this is quite a ways from downtown Fort Worth. So they've got little offices around the city. And I asked for someone to arrest the bailiff, the JP, and the constable. And while I'm waiting for a sheriff's deputy, the constable came back over, and he said, well, Mr. Kelton, if you want me to, I will talk to the prosecuting attorney about this. Oh, no. Don't you dare talk to the prosecuting attorney about this. I'll get to the prosecuting attorney, but before I do that, I need the sheriff to touch my tar baby. He said, your what? My tar baby. I got this little invisible tar baby. And I'm trying to get everybody to touch it. The judge touched it, and the bailiff touched it, and you touched it. Now we get the sheriff to touch it. And once he touches it, now then we'll go talk to the prosecuting attorney. And the sheriff captain came in plain clothes. And he said, are you Mr. Kelton? I said, yes, I am. He said, well, what can I do for you? I said, you can go over there and arrest the JP, and you can arrest the bailiff, and arrest this constable over here. And the constable's just standing there kind of shaking his head. And man, I can't arrest the JP. I said, sure you can. Just go over and throw the cuffs on her and drag her off to jail. Man, I'm not arresting JP. I'm off duty. Wait a minute, Captain. You are a certified police officer, aren't you? He said, yes, I am. Then you know you're never off duty. Well, I'm still not going to arrest the JP. And I turned to the bailiff. See, he touched my tar baby. I think I'm done here, guys. And I walked out. I don't ever ask them to do something I actually want them to do.
Yeah.
Everything's a setup.
Right.
So get your little tar baby. Ask someone to do what the law commands him to do.
Right.
And hope he don't do it. This also helps you from feeling betrayed by your public officials.
Right.
Expect them to do the wrong thing, and the first time one of them sounds tense, ask them, are you getting agitated? Agitated is their little key word. If they say agitated, everybody sees you as out of control, wacko, nutso, pro se. So first thing I want to do is ask him if he's getting agitated, or tell him not to get agitated. Oh, they hate that.
Now that's called misfeasance in office when they don't comply with what they should, right?
Yeah, malfeasance and misfeasance. Malfeasance is where you purport to exert an authority you do not expressly have. Misfeasance is where you fail to perform a duty you're required to perform. Both of them are official misconduct. Some states call them official oppression. Here in Texas, we have both. Official misconduct goes to misuse of public funds or county equipment in some way. That's generally what that's applied to. Official oppression is a statute that goes to where if a public official fails to perform a duty he's required to perform or exerts or purports to exert an authority he does not expressly have, and in the process denies a citizen the full and free access to or enjoyment of the right, i.e. petition the court for redress of grievance, then that's a Class A misdemeanor in Texas. It's Class A misdemeanor. It's whatever they call it in the different states. It's generally one level under a felony.
Okay.
And most every state has it because it mimics the Ku Klux Klan Act. Most everybody's familiar with 42 U.S. Code 1983. Under Brady, you can sue them under 42 U.S. Code 1983. That's the second half of the Ku Klux Klan Act. The first half said if a public official acting under the code of his authority fails to perform a duty he's required to perform or exerts or purports to exert an authority he does not expressly have, that's a federal crime. If it's in the Fed, then every state has adopted a similar statute. It is a catch-all. Everybody should have that one memorized.
That's what I was going to ask you. Where do I look to find out if it would be
Penal Code? It'll generally be there's going to be a section for offenses by public officials. This is an offense that only a public official can commit. You'll have a section on that.
In the state statutes?
Penal Code, State Penal Code.
State Penal Code, yeah.
Now, these are penal statutes. It's like your Open Records Act. I don't know what it is in every other state, but in Texas, they say, well, if he didn't give you your records, you need to sue him. No. The Open Records Act is not a civil statute. It's a penal statute. Right at the end, it says violation of this code is official misconduct and a Class A misdemeanor. So
that's interesting. I wish I knew that a while ago because I asked under the Public Records Request Act, I asked the judge here where the traffic citations, where the money goes. And I gave him the Public Records Request Act number.
Okay. You can only request of him records that are in his custody and control. And that's probably not in his custody and control.
Okay.
Records of the court are. Now, there are two kinds of records of the court. You have criminal records that go to the adjudication of cases. And that doesn't fall under the Open Records Act. That falls under Constitution, a public court. He has administrative records that fall under Open Records Act.
Okay.
They generally don't make those distinctions.
Right.
Okay, but have fun with this and just run the routine on them.
Yeah, I'll do it, Randy.
You'll find it is so much fun. I'm about to go to Mark, and just listen to Mark. He can tell you how much fun it is. Okay.
It's your time.
Thank you, Tyler.
Thank you.
Okay, Mr. Mark, how are you doing?
Well, I'm doing relatively okay these days. Of course, the case that had been consuming a large portion of my lifetime and questions with you got settled, which I believe you know from emails and such.
Mm-hmm.
I don't remember if I mentioned the settlement and such to the radio audience, though. And if you wanted me to go over briefly the lawyer casualty.
Yes, that's the best part.
All right. Well, the lawyer casualty is a lawyer who touched the tar baby in the sense that he had previously did two of the cases where the documentation showed that the gentleman was an owner in the company and was being denied in the paperwork filed in my case. He was a partner at the law firm. He had a divorce a year and a half ago, and after I filed the judicial conduct complaints, after they were resolved, he was no longer with the firm anymore. So somebody who was a partner is now off apparently in solo practice. Now, it could be that, he had a change of heart after the divorce. Could be lots of reasons. I don't know if I can take credit for him leaving the law firm.
But you get to think that you did.
Well, it's kind of like the judge who committed suicide on the day I showed up in court. I might be the reason, but I'm guessing not. I'll get to that one for your benefit after I get finished with the settlement and such. In the settlement, I was able to talk them into part of the settlement being I can continue talking about this case for all infinity and share the documentation with anybody I want. The only real problem I found in the settlement agreement after I signed it, at the top of it, it says attorney is defined as the husband and wife team. And then in the middle of the document, it says the attorneys are being held harmless. So is that a typo? Does that magically include the other attorney? Because the attorney who I agreed to sign with, we had multiple conversations going, no, it's you, not them. And he agreed to it on the phone. So does that plural cause me a problem?
Yeah, it could. You might want to go in and have that redacted.
Okay.
Okay, hang on. We're about to go to break. Randy Kelton, Deborah Stevens, Eddie Craig, Rule of Law Radio. Our call-in number, 512-646-1984. Give us a call. Get in line. We're having way too much fun today. So this is our top-of-the-hour break, so we will be about 3 or 4 minutes. So you got time to get up and go stretch and get a cup of coffee and not miss anything. So we'll be right back on the other side.
Would you like to make more definite progress in your walk with God? Bibles for America is offering a free study Bible and a set of free Christian books that can really help. The New Testament Recovery Version is one of the most comprehensive study Bibles available today. It's an accurate translation, and it contains thousands of footnotes that will help you to know God and to know the meaning of life. The free books are a 3-volume set called Basic Elements of the Christian Life. Chapter by chapter, Basic Elements of the Christian Life clearly presents God's plan of salvation, growing in Christ, and how to build up the church. To order your free New Testament Recovery Version and Basic Elements of the Christian Life, call Bibles for America toll-free at 888-551-8888. 888-551-0102. That's 888-551-0102. Or visit us online at bfa.org.
Live Free Speech Radio, LogosRadioNetwork.com.
You're listening to The Liberty Beat, your daily source for liberty news and activist updates. Online at thelibertybeat.com. John Bush here with your Liberty Beat for February 8th, 2013. Gold opened today at $1,677. Silver at $31.76. And Bitcoin is trading at $22.39. Today's edition of the Liberty Beat is sponsored in part by Central Texas Gunworks, offering firearms training courses, concealed carry classes, and firearm sales. Online at centraltexasgunworks.com. And now the news. A former Los Angeles cop with military training vowed war against other men in blue Thursday, leaving one officer dead days after he allegedly killed two other people to begin a wave of retribution for being fired, police said. The focus of the intensive, expansive manhunt is Christopher Jordan Dorner, a 270-pound former Navy lieutenant who has professed his venom against LAPD officers he claimed ruined his life by forcing him out of his dream job. Dorner blames one retired officer for bungling his appeal to get his job back in an 11-page manifesto in which he has also complained of mistreatment by the LAPD. In that letter, he vowed to violently target police officers and their families, whoever and wherever they are. The chairman of a Senate committee recessed John Brennan's CIA confirmation hearings and cleared the room after protesters persistently interrupted the proceedings.
Speak for the mothers.
All right.
Children.
We will stop again.
In Yemen,
all right.
Pakistan, Somalia, and where else?
Please remove that woman.
And the Obama administration refused to even tell Congress.
Police removed several protesters at the beginning of the hearing on Thursday. More began yelling after Brannon began testifying, and Intelligence Committee Chairman Dianne Feinstein ordered the hearing recessed while the room was cleared. The protesters were shouting objections to lethal U.S. drone strikes and harsh interrogation methods. A severe winter storm is barreling towards some of the most heavily populated parts of the country today, closing thousands of schools, causing massive travel disruption, and threatening to bring more than 2 feet of snow and gale-force winds to much of the Northeast. The National Weather Service issued blizzard warnings from North New Jersey, northeast to Maine, and with New York and Boston expecting to be among the hardest hit. Airlines canceled more than 2,400 flights across the region as the storm barreled eastward from the Midwest and Great Lakes, according to FlightAware.com. The Liberty Beat is sponsored by Parents for Liberty, bringing the philosophy of liberty to parenting and parenting to the philosophy of liberty. Online at parentsforliberty.org, and by Brave New Books, specializing in free-thinking material for free people since 2006. Online at bravenewbookstore.com.
It's all according to the will of the Almighty. I read his book and he says he cares not for the unsightly. These warmongers come by that term rightly. I won't pay for the war with my body. Ain't gonna pay for the car with my money.
Okay, we are back. Randy Kelton, Deborah Stevens, Eddie Craig, Real Law Radio, and we're talking to Mark in Wisconsin. And when we went out, you were talking about the plural and the two lawyers.
Right. The like I said, the original the definition section of the agreement says attorney and defines both him and his wife, and in the middle it says attorneys. Do I then claim that that's just a typo, or do I go ahead and
does the agreement anywhere reference one or the other of the attorneys separate?
It explicitly says of the law firm blah and attorney blah and attorney blah.
Okay,
so they are referenced separately. In the attorney refers to these two people as attorney.
What does the plural? What is the significance of it?
It's just sitting in the middle of the document. Again, I have multiple phone conversations with the attorney who I did.
Wait, but I don't understand what you're trying to protect or what issue you're trying to protect.
I'm trying to go after the attorney of the other party that was named, the one who filed the affidavit, which is a felony, not false filing, but where you lie in the your affidavit.
Aggravated perjury.
Perjury, yes, felony perjury, and the document that is a cloud of dots for the signature of the attorney or of both attorneys. A cloud of dots is how the stamp is made up of, and solid lines where they crossed out date expires on, and the cloud of dots says is permanent, and then the date is written in strong pen, no cloud of dots, on the copy that I have. Keep in mind that this purported affidavit, when I asked him, I said, well, submit it to the court. He said, I'm not going to do that, which again shows up in a transcript that I submitted to the court and I have an audio recording of. So you have a situation where a lawyer is writing an affidavit and says, I'll send it to you, but not the court.
That is interesting. Did that get a bar grievance?
That one was that one arrived just after I had bar grieved him, and the state said no, nothing had happened. So it's kind of my ace in the hole for the lawsuit for treble damages that I'll eventually file.
Okay. If we're back to the plural implying that you can't go after this person for perjury, you cannot contract with anyone to violate law.
Okay.
And most every state makes it essentially misprison a felony if you don't report. If you have knowledge of a felony, you don't report it, then you become a criminal perpetrator. And you cannot contract away that liability.
Then that's beautiful. I do have a venue question about that upcoming lawsuit against the attorney, and this would be the same law firm where the one attorney is no longer there. Now, the law office who created the suspected forged document and the false affidavit was in County, we'll say, M. The suspected forged document was sent to me in County M. The false affidavit was sent to County W and submitted to the court. So, where should the venue be placed? And the other question becomes, is there a way for me to wander up to the black robe judges in one of the counties and go, you want this turkey? And get one of them to the venue.
Essentially, you can file any county that would have venue on any issue could take venue on all the issues. So you can file in any county. Like here in Texas, if someone commits a tort, you can file on them in the county in which the tort was created. And if the tort spanned more than one county, in either county that the tort occurred in or any county in between.
Okay.
So they would have equal venue, unless it's different in Wisconsin, and I doubt that it is.
I doubt it would be. Now, another thing, while I was wrapping up this case, I found interesting address issue in a case that the guy was suing was involved in. He contracted with the law firm with the lawyer casualty and gave an address for an entirely different location where, one, he was not living, but two, was an actual different lawyer's address. That lawyer did family law. So when you submit an address to the court, is that supposed to be someplace where you actually are at, or is it more like a corporate, what?
No, it's just a place where you can get mail.
Okay, great. Yeah. But it can't be a P.O. box.
that may be something particular. They probably want a residence so they can find you.
Okay.
But as far as perjury or anything like that, there's nothing of that nature. So long as if the mail comes to that location, if the mail will get to him, that he's covered.
Okay, that's fine then. Now, one of the in the upcoming lawsuit, I'm looking at a local federal government employee, assuming that the 1 year, it falls under 2 years as opposed to 1 year on the federal level. I'm thinking of going after him directly and not involve the city, simply because he was using his own personal car, and I have that documented on video, where I asked about his transportation, and he said, I've got my own personal car. Because I understand that the reason cities can get involved in police-centric lawsuits because they're cruising around in city-owned property.
Yes. That's one of the things that the municipalities and the counties and the states waive their sovereign immunity over.
Okay.
If there's a county employee operating a backhoe and he sticks it through the window in your car, they can't claim sovereign immunity. They waived it.
Okay.
So if a public official or an employee of the governmental agency creates a tort while using a motor vehicle, actually it says a motorized piece of equipment, so it includes other things besides motor vehicles, and that's generally for the road crews and such. So they have no sovereign immunity for those things.
Okay. So this would definitely fall to him rather than the city.
Yes.
Okay. Good.
Was he an employee of the city?
He is building inspector.
If he's acting under the authority of the city, you got them anyway.
Yeah, well, the problem is if I go after he's an employee, I only have 90 days in which to make the lawsuit happen, and it's well past the 90 days. If I say that the city isn't involved because he was driving his own car and he was acting under color of law, then I may have the clock.
You may have standing. If you could show he lacks subject matter jurisdiction, then he's impersonating a public official, and he doesn't have a right to qualified immunity.
Well, and the impersonation would be he slapped the condemnation notice, and I have the video to my face where he said, yeah, I did that to get your attention.
Knowing it was false.
Yep, that would be my claim.
Ooh, executing a document by deception.
Ooh, that's a new one. Thank you.
Well, we have that statute in Texas, and they passed it for the Republic of Texas. But even if you don't have that statute, you've got tampering with a government document.
Okay.
If he places on a document a statement that he knows is untrue and intends that it be taken as true, that's tampering with a government document.
Okay. Now, the problem for me bumping that up into a federal lawsuit is I have a right to life, liberty, and the pursuit of happiness. I don't have necessarily a right to access of a property. And what
Wait a minute, hold on. Access to your property.
Because the condemnation notice says, after 24 hours of this, you are no longer allowed in your property.
That's the thing. You don't have the right to privacy of your person. You do have the right to be free from search or seizure of your property, not your person.
Okay. Well,
and that's effective seizure of the property.
Okay. Well, once I get these other ducks in my life in a row, I may be contacting you separately to contract with you, give me some assistance on this one. Let's see. Venue, that one's taken care of. All right. The only last one is recording in a courtroom. Now, pretty much everybody says you cannot record in the courtroom. Recording instruments are not allowed.
That's not what Glick said.
Okay, well...
The Glick court said absolutely it is a well-settled First Amendment right.
Okay.
That private citizens can videotape their public officials in the performance of their duty.
Okay, well, here's my little twist on it. In Wisconsin, if you are a notary, you can act as a court reporter. Court reporters are allowed to record as part of their court reporting duty. Now, to get to the dead judge, that's how this comes in. I'm a notary. I have my stamp here. I have my, certification. I'm going to act as a court reporter in this case. Now, I had an associate of mine who there's a whole lot of not money in his life. And so I said, you need to have a court reporter there for your divorce. So I wander into the courtroom before he is, and I start setting up on the other side of the bar. And this gal's looking at me, and she finally comes over and says, what are you doing? I said, I'm here. I'm a Wisconsin notary. Here's my paperwork. Here's my stamp. I'm here today to function as a court reporter, as we're allowed. She looks at me, her eyes get a little wider, and she scares off behind in the closed room. Then 2 or 3 other people come in and look at me, and they skitter off. And then finally the other 2 parties show up, and she says, yeah, the judge is too busy today. He can't see you. So follow me. And so I start unpacking. She goes, you don't need to come. I said, yes, I do. So we leave the courthouse and go into a disused room in the Justice Center where the sheriff and the police were in. And so in this disused room, then they had their meeting.
Ooh, that's interesting. Okay, we're about to go to break. I'd like to look at that on the other side. I take it she didn't interfere with your recording on the other in the other room. Okay, this is Randy Kelton, Deborah Stevens, Eddie Craig, Rule of Our Radio. Our call-in number, 512-646-1984. We'll be right back.
All the talk about gun grabbing got you down? How would you like to be the proud owner of a brand new AR-15? Then go to LogosRadioNetwork.com and enter the drawing to win a free Rock River AR-15, sponsored by Zombie Killers Ammo and Guns. Support Logos Radio Network by donating just $20 to their fundraiser, and you'll get your name entered into the drawing. Second place prize is a Spikes Tactical AR-15 Lower Receiver, sponsored by CentralTexasGunworks.com. Every $20 you donate will put your name in the hat, so increase your chances of winning by increasing your donation. Winners must be eligible to lawfully own and possess these items. Please visit LogosRadioNetwork.com for details. If you love all the liberty-minded programming on Logos Radio Network, contribute to the fundraiser and secure your chance to win a Rock River AR-15, sponsored by Zombie Killers Ammo and Guns. Like them on Facebook at Zombie Killers LLC. Contest ends February 28th. At Capital Coin and Bullion, our mission is to be your preferred shopping destination by delivering excellent customer service and outstanding value at an affordable price. Capital Coin features a great selection of high-quality coins and precious metals. In addition to providing the best prices in the nation, we want to bring you the best shopping experience both in-store and online. In addition to coins and bullion, we carry popular longevity products such as Beyond Tangy Tangerine and Pollen Burst. We offer freeze-dried storable foods by Augustin Farms, Berkey Water Products, ammunition at 10% above wholesale, and more. You can lock in a spot price with our silver pool, and we set up metals IRA accounts. Call us at 512-646-6440 for more details. We're located at 7304 Burnett Road, Suite A, about a half mile south of Anderson. We're open Monday through Friday 10 to 6, Saturdays 10 to 2. Visit us at CapitalCoinandBullion.com or call 512-646-6440.
This is the Logos Radio Network.
Ain't gonna blind me. Don't bore me. Well, ain't gonna fool
Okay, we are back. Randy Kelton, Deborah Stevens, A. Craig, Rules Law Radio. And we're talking to Mark in Wisconsin.
Okay. You wanted to ask me any questions about the moving a court hearing into the...
Yeah, and another room. Did the judge show up?
Nope. As far as I know, the judge never showed.
Was this a mediation hearing?
Yes, it was a mediation hearing, and I believe it was even checked into the courthouse record as a mediation hearing.
Oh, okay. So the judge really didn't need to... Who was the mediator? Or was this an informal... I take it since you were acting as a court reporter, it was not informal mediation.
She said, I believe it got marked down as informal mediation in the record. But ultimately, it didn't matter. The other party didn't invite me to any of the other meetings. And the other part is he did admit that the staff treated him entirely differently when I was there.
Funny how that happens.
Yeah, exactly. That's a hat tip there to Mr. Graves, about the importance of this. In fact, my case would have been entirely, in County W, would have went entirely differently if I had not been paying the court reporter, because there I have the county commissioner going, this case is taking way too much of my time, and many of the other things that would allow me to say that part of the reason to get something bumped into a federal courthouse, I do not believe a pro se can get justice. And again, hand the court all records from this case with the 500-plus pages and go, see here. Now, the other incident where I went ahead and played court reporter was a gentleman who was fighting a foreclosure and trying to do more patriot mythos than either you or what the gentleman from did the radio show on the We the People radio network, Skidmore? Steve Skidmore?
Skidmark.
Skidmark? Okay. Well, anyway.
Skidmore.
Yeah. Anyway, he wasn't doing that. He was trying to tell me how if I write a check to the Federal Reserve, I can stop paying taxes, blah, blah, blah. So listening to him try and play junior boy judge or junior boy lawyer just got me head shaking. But I'd show up in a county which we'll call County R, so I had to drive, a good 75 miles out. I'd show up, and I was told, judge isn't here. Judge's not going to be here. And, having previously went, I'm here in this capacity, and the judge not being there, I went, okay, fine. On the third time, they said he's not here, and it turned out an hour earlier he had shot himself in the head at the local park. No other information was ever publicly forthcoming as to why or anything else. I doubt, and I never actually saw the guy at all. But that was my second round of playing as a notary playing a court reporter.
He really didn't want to see you.
That's one version we can go with, But my final question then, I'm wanting to bring charges against the plaintiff, the defendant in this case, for his false pleadings. Now, the other thing is he has a history of jerking around people, including in one Milwaukee court. When the court sent him a letter, he wrote on it, refused, return to sender. In addition, in a different case, or maybe it was that case, he had a pleading saying, please don't find against me because I don't have the money to pay. Well, on the day when he got a judgment against him, but the amount wasn't decided. Then 3 days later, the amount was decided. Well, the next day, they made a filing with the Wisconsin Department of Financial Institutions that the business address was changed, or that the person who was the contact, the registered agent, was withdrawing. And the address was for a location that they had been evicted from a few months earlier. And then the next day, they then formed a new corporation under a different name. Now, to me, that looks like skullduggery and giving a giant finger to the court.
That sounds like, what's the term? That he's I want to say a nominee, but he's the alter ego. The new corporation is an alter ego of the old corporation.
Nowhere with the state of Wisconsin, part of what you're supposed to do is when assets are transferred from one corporation to another, you're supposed to make a filing. None of that was done. So we have years of him, saying, I'm not the company, years of this other stuff going on as low-level noise. There's probably crimes there. And I'd really like to just bypass the DA and go directly to the grand jury. So should I pick one of the judges that he jerked around and ask them to formally stick me in front of the grand jury?
No, just run the routine on the prosecutor first, so you can come back to the grand jury and go to the bailiff and say, instruct the foreman that I have business with the grand jury. He's going to say, can I tell him the nature of the business? He says, yes, you can. You hand him these files, and when he looks at it, you tell him, now, I know what you're thinking. You're thinking I should go talk to the prosecuting attorney about what to do here. Bad idea, Bubba. These complaints contain criminal complaints against the district attorney, and if you go to the district attorney with these, I'll consider that an act of obstruction of justice. I told that to a bailiff in Johnson County, and he stood there a minute, and that was the bailiff who really hated me, and I had crawled down his throat 3 or 4 times. The only bailiff there who ever heard a sharp word from me. I got along great with all the rest of them. But he had an attitude, so I helped him out with it. And in spite of the fact that he hated me, he decided that maybe this guy's not kidding, and he really will try to put me in front of a grand jury. So he gave him to the grand jury, and I actually presented the district attorney to the grand jury in that case. So if you want to get to the grand jury, that's the best way I know to set them up.
Okay. What do you think of just asking one of the judges nicely and, point out I have business with the court, ask the judge nicely, and then run the routine?
You can. You run the routine on the judge.
Okay.
If the judge refuses, then you give the judge the complaints, and he has a duty as a magistrate.
Okay, I'll have to confirm that's the case in Wisconsin.
Yeah, that's been in place since 1215. Every judge is a magistrate. It's going to be that way in every state.
Okay. Well.
And that's because when the country was put together, that's why you have JPs scattered around the county. So if somebody gets arrested, there is a justice of the peace close that they can take the person to and hold an examining trial.
Okay.
So that should be pretty certain. Okay, go ahead.
I believe that covers everything that I've got here today.
Oh, good. You're having entirely too much fun. I've told you that before.
Oh, there was quite a bit of stress at the point where the commissioner in the case was going, yeah, you're not getting any more discovery, and I don't really care that you've shown and handed me a document here today that says in February he signed as the agent of a non-existent corporation. I don't really care about that. I'm still going to believe what the his original affidavit says. I'm taking everything that's stated there as the god-awful truth. So
that ought to be fun going after him. failing to apply the law to the facts. The law to the facts. He has a duty to determine the facts in accordance with the rules of evidence and then apply the law to the facts.
So basically,
that's a ministerial duty. Not for the decision that he made, but for what he failed to do that would have caused him to come to the right decision. Okay, thank you, Mark. This is Randy Kelton, Deborah Stevens, Eddie Craig, Rule of Law Radio. Our call-in number, 512-646-1984.
Burglars are breaking into hotel rooms by effortlessly and silently opening those key card locks. I'm Dr. Catherine Albrecht, and I'll be back to tell you how the hackers do it and what it means for you, the traveler, in a moment.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This message is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
When Janet Wolf returned to her room at the Hyatt in Houston and found her laptop stolen, there was no sign of forced entry, and the housekeeper was ruled out as a suspect. So who done it? A hacker, it turns out, using a digital tool that spoofs the computerized keycard locks in place at 4 million hotel rooms. After break-ins across Texas, the lock company Onity offered a pretty lame solution, plugging the locks with putty. The real solution requires replacing every lock circuit board, something Onity wants the hotels to pay for. But what if they don't? Well, it may be time to stay somewhere else. Motel 6, anyone? I'm Dr. Catherine Albrecht for StartPage.com, the world's most private search engine.
A Noble Lie, Oklahoma City, 1995, will change forever the way you look at the true nature of terrorism.
Based on the damage pattern to the building, what the government says is impossible.
The grand jury did not want to hear anything I had to say.
The decision was made not to pursue any more of those individuals.
Some of these columns were ripped up, shredded, tossed around.
The people that did the things they did knew doggone well what they were doing.
Expose the cover-up now at ANobleLie.com.
At hempusa.org, we offer chemical-free products to people around the world, detoxifying, self-healing, while rebuilding the immune system. We urge our listeners to please consider our largest-selling product, Micro Plant Powder. Our Micro Plant Powder is rich in iodine, probiotics, zinc, and silica to help rebuild the immune system and to create a healthy stomach flora. Micro Plant Powder is excellent for daily intake and is perfect to add to your storage shelter. We urge our listeners to please visit us at hempusa.org. And remember, all of our products are chemical-free and healthy to eat. We constantly strive to give you the best service, highest quality, and rapid shipping anywhere. And we offer free shipping on orders over $95 in the U.S. Please visit us at hempusa.org or call 908-691-2608. That's 908-691-2608. See what our powder, seeds, and oil can do for you at hempusa.org.
Looking for some truth? You found it. LogosRadioNetwork.com.
Okay, we are back. Randy Kelton, Deborah Stevens, Eddie Craig, Rule of Law Radio, and we're going to Marie in Texas.
Hi, Randy. Thank you so much for taking my call. I have an attorney who's filed a complaint to foreclose for homeowners association fee. Are you there? Hello?
Yeah, I'm here. Okay, he filed you said a report or a complaint?
A complaint.
Okay.
To foreclose for non-payment of homeowner association fee.
That's one of the toughest things to fight. And it's a real scam around the country, and it's not one of the things I have had time to investigate yet. What was your question about that?
I would like to file a restraining order, but I understand I have to file a complaint first.
Yeah. So what would be your complaint?
That he misrepresented the facts.
Oh. Okay. Is it a substantial misrepresentation?
Well, he's telling the court that I didn't pay, and I did. I have so far paid over $1,000, and he refused and returned the check.
Oh. Then you should. Okay. Then let me think about that. Then. Okay. You should file under FDCPA. If you sent offer of payment. And hold on. How much was in arrear?
It's about $700, $800 because he's charging $500 attorney fees.
Okay, and you sent a check for excess of that amount, and he refused to take it.
I sent him the fees for the homeowners association. I sent it to the homeowners association also. But they have refused and returned them, and he returned it because I didn't add the attorney fee.
Then you should countersue them for fraud. Offer made and not accepted is how does it go? Once you made the offer, if they refuse to take it, it's paid. So when did he sue? How long ago?
I filed an answer on the 28th.
Okay. Did you countersue in the answer?
No. I noted that I had sent the checks and they had returned them.
Then countersue, file an amended answer with a counterclaim.
Okay. How do I articulate?
Ask the court to rule that the offer to pay was denied. Therefore, under the Uniform Commercial Code, the debt is paid. And this goes under FDCPA. You can sue them in the federal court.
I should go, because he filed in county. I should go to federal court?
Oh, yeah, that'd be great fun. This FDCPA.
What does that stand for, Randy?
Fair Debt Collection Practices Act.
Fair Debt Collection.
And yeah, he is attempting to foreclose on a debt. He's foreclosing on your property for $700.
Yes, and
that he refused to take payment on. That should get a bar grievance against him immediately. That'll double his malpractice insurance. And then an FDCPA suit. And that's relatively easy to do.
Okay. And
go to Remedies in Real Estate.
Where?
remediesinrealestate.com. And click on the free forensic analysis.
Okay.
And it'll bring up a map. And look for consumer protection laws. I think it's under gathering information. And there's a FDCPA questionnaire in there. It's a little clunky. It's not. I need to do a little work on it, but it has all of the standards in a questionnaire format. And you just walk down it. Did he do this? Did he do this? Did he do this? And pick the one he did. Oh, you only need one.
Okay.
And then you can sue him in the federal court.
Okay. Now, my question is, how do I articulate on the complaint that he did that he misrepresented facts?
Okay, I pretty well know the Uniform Commercial Code, but I don't have the codes stuck in memory. But all of these patriots have talked about this for a long time. offer tendered is payment tendered is payment made. And you need to find in the Uniform Commercial Code where it says that if you offer to tender payment and it's refused, the payment's considered paid. And that's where they come in. The lawyer can't refuse the payment just because his fees are not in there. So a bar grievance against him would double his malpractice insurance. It'll cost him $20,000-$30,000 a year right off the bat.
Okay.
That'll let him know you know how to beat him up.
Okay.
And then file an amended complaint with countersuit. Or you can just file a countersuit. And let them know you're going to make them pay.
Okay. And then what about the restraining order? How do I word the restraining order?
Okay. Well, the restraining order, way too complex to do on the show. Okay. You can do a search on the internet for foreclosure restraining order. In a restraining order, okay, let me back up. This doesn't call for a restraining order. Restraining order means temporary restraining order. You want a preliminary injunction.
Okay.
So look up preliminary injunction. You have to show that there is a reasonable likelihood that you'll prevail in the case, and that if they are allowed to foreclose, it will create an unreasonable harm that cannot be corrected, and that the restraining order will not place an undue burden on the other party. And in this case, since the other party refused payment, they can't claim burden at all. And you should accuse the lawyer of churning the case over a pittance or fomenting litigation by refusing to accept payment. He used that as an excuse to create litigation. So you accuse him of fomenting litigation and definitely grieve him for that. Now, you can also go to bargrievance.net and click on American Bar Association Model Standards. I've got that in a questionnaire format as well. And follow the questions. You'll find the one that goes to what he has done and write a bar grievance against him on that. That'll make him nuts.
Okay, wonderful.
But look up preliminary injunction, and you'll find a document that'll show you what the matter of fact. I was loading up the website today with that kind of information, but somehow I crashed it, so I had to take it out. When the show started, I was working on trying to remedy a little problem, but I have a bunch of about 2,000 forms that I was posting up, and that's what crashed my website. I'll have that soon, but just do a search for preliminary injunction, and you'll find some, and read them over, and it'll become real clear what you have to do.
Okay, and I'll need to file that form with the court.
Yes.
Oh, and I meant to ask you, Randy, what is the timeline for the docket once I file my response?
Once you filed your answer, it's up to the other side. The state court is, I'm not as familiar with the peculiarities of each state court, but generally in the state court, the answer you've got until the Monday after the 21st day in Texas, and same in the Fed. But generally on everything else, you have 30 days. In the Fed, you got 10 days.
And now we have sheriffs saying, you're not going to do that here. We don't care what laws you pass. You want to play with those little things in Washington, D.C., that's fine. But you're not doing it in my county. As long as I'm the sheriff here, we will draw the line in the sand, and we draw the line with freedom.
Join Sheriff Mack for 2 special free engagements in Austin this week as he encourages you and local law enforcement to stand up to the federal bullies aiming to take away our rights. Sheriff Mack will be speaking this Friday at Hills Cafe, 4700 South Congress Avenue at 7 p.m. And on Saturday at 7 p.m., he will be speaking at your favorite local Liberty bookstore, Brave New Books, located at 1904 Guadalupe. For more information, please call the bookstore at 512-480-2503. And remember always, Austin, be brave.
Are you the plaintiff or defendant in a lawsuit? Win your case without an attorney with Jurisdictionary, the affordable, easy-to-understand 4-CD course that will show you how in 24 hours, step by step. If you have a lawyer, know what your lawyer should be doing. If you don't have a lawyer, know what you should do for yourself. Thousands have won with our step-by-step course, and now you can too. Jurisdictionary was created by a licensed attorney with 22 years of case-winning experience. Even if you're not in a lawsuit, you can learn what everyone should understand about the principles and practices that control our American courts. You'll receive our audio classroom, video seminar, tutorials, forms for civil cases, pro se tactics, and much more. Please visit ruleoflawradio.com and click on the banner or call toll-free 866-LAW-EASY.
Well, you know karma is lurking around the corner. You better watch every step you take. And good will follow you. Yeah, Brother Jerry, sing reality. Okay, karma is lurking around the corner. Sing, Jerry, come!
As we sow, so shall we reap.
Okay, we are back. Randy Kelton, Deborah Stevens, Eddie Craig, Rule of Law Radio, and we have lost Marie, so we're going to go to Johnny in Tejas.
Hey, Randy.
Howdy.
How are you doing tonight?
Tired.
Yeah, I bet you are. Well, as you know, I have an eviction hearing coming up in a few days, and I have just a couple of questions related to, in addition to other things that are being worked on, maybe some other things that I might be able to raise, just to kind of set the background. You already know this, but just for anyone listening. There is a company in Delaware who purports to have purchased my property in a substitute trustee sale. This company has hired a property management company out of Austin, Texas, to manage their properties for them. And then this company in Austin has, in turn, they basically hire a realty company in Dallas to go all around Dallas-Fort Worth, placing notices to vacate on people's doors all day long. And I got a notice to vacate on my door that was signed by a realtor of this company. Okay, one of the things that I was considering raising at the eviction hearing is the issue of agency. Under the property code, where it talks about Section 24 of the property code, a demand for possession and a notice to vacate prior to filing eviction suit must be made by the landlord. And the landlord is consistently defined as an owner, lessor, or sublessor of a dwelling, or an agent of that owner. Okay, what I suspect is going to happen, now that this Delaware company has hired an attorney firm out of Houston to handle this eviction case, so I don't know if they're going to come all the way to Dallas. I suspect or to Fort Worth, but I suspect what's going to happen is one of the realtors or somebody from the property management company is going to show up and stand in the eviction case.
They can't do that. They have to have a lawyer.
Okay. Well,
what they'll probably do is hire a lawyer here to stand in, but the lawyer cannot establish agency for the agents.
That's where I was going to go. Corpus juris secundum, second and third restatements of the law of agency, American jurisprudence, and a ton of Texas case law says that agency cannot be presumed. It must be proved to exist and cannot be proved out of the mouth of the agent. So
must be proven out of the mouth of the principal.
Correct. So I'm looking at the aspect of this third-party realtor who signed the notice to vacate. You know, that's a filing.
The notice to vacate's not relevant. Who did the eviction under whose name? I take it a lawyer signed the petition for unlawful detainer, but I take it he did that under the name of the Delaware company?
Well, when I got served with the citation, there was a letter included, which I never got. And it is, it just says, it tells who, the letter from the attorney says who they represent, refers to them as the owner. And it says, our client owns the above referenced property, which you are occupying. And the property was sold, and you're now a tenant at sufferance. And
is the owner's name on a warranty deed?
It's not on a warranty deed, no.
Then you can maintain you still own the property.
Okay.
There's nothing in the record to indicate that these people purchased the property. If they maintain they have a claim, if it's not filed in the record, it's not valid under 13001.
Well, you said a warranty deed. Do you mean a substitute trustee's deed?
That's what a substitute trustee's deed is, essentially a warranty deed.
Okay, well, there is a substitute trustee's deed filed into the county record.
Oh, okay. Bummer. Sometimes they don't get that done. But,
yeah.
Okay, any claim against those third parties won't be relevant.
Will or won't be?
Because the party just notified you to leave the property, didn't take any legal action against you. So you'd have no claim against him. And if the notice was not in this person's name but was in the name of the owner, you're not going to have any claim there.
Well, what I'm looking at is specifically under 24.005 of the property code, notice to vacate prior to filing eviction suit. It sets out that a notice to vacate has to be done prior to filing the eviction suit, and that it has to be done by the landlord, which is the...
Well, yeah, but the courts are going to read that to say that the landlord himself does not have to walk down there and place the notice himself. He can engage someone else to do that for him.
Okay.
And the courts are going to say, if the notice is in the name of the landlord, then the notice doesn't make any difference who brought you the notice, only that it's in the landlord's name.
Okay.
We have a lot of other ways to go after subject matter jurisdiction. And that's where we want to go to. We have an eviction hearing coming, and the judge, the JP, is going to rule against you no matter what you do.
Yeah. Well,
so we'll file a challenge to subject matter jurisdiction, get the judge to deny it. Then we'll do removal, and hopefully the judge will try to do a little song and dance after the removal. And if he does that, then we get to file criminal charges against the judge for impersonating a judicial officer.
Yep.
And when he denies the challenge to subject matter jurisdiction, best way to handle that is not to appeal it, but to sue the judge in his personal capacity.
Yeah, and that actually goes to my next question. There's a bunch of Texas case law which says that basically, if you seek the affirmative action of a court on any question other than jurisdiction, it's basically a general appearance and paraphrased a grant of jurisdiction, basically. So does that mean that if I file a motion to dismiss on any grounds other than jurisdiction, and I've also seen Texas case law which says that...
No. You can, so long as you can file other motions along with a plea to the jurisdiction. And when you stand in the court, it doesn't make any difference which one the judge hears first, so long as they're all filed together.
Okay.
So you can file, it's appropriate to file other motions in case the judge dismisses. You don't waive all those other issues. But once the subject matter jurisdiction is filed, it stands, so that you cannot subsequently give the court jurisdiction if it didn't have it in the first place.
Okay. Now, I have seen some appellate court opinions which say or allude to just the act of asking for an appeal is considered a grant of jurisdiction.
Yeah, it is.
Okay.
But not if... No, you have to read that in context. If you're asking for an appeal on a challenge to subject matter jurisdiction, that is not as an admission. If you ask for an appeal on any other grounds without the subject matter jurisdiction issue, then you've waived it.
Gotcha.
Or you've waived your position.
Action.
But the thing about subject matter jurisdiction, this is what I pulled on them in Collin County. The lawyer complained to the judge that I just gave him this 30-something page challenge to the jurisdiction 2 hours before this hearing. And I said, "Oh, Your Honor, he knows better than that. This is a challenge to subject matter jurisdiction. It can be filed at any time."
Right.
The judge was not happy. He knew I set him up with it. I did that on purpose. So, point of that is, you cannot ever waive subject matter jurisdiction, period.
Yep. You
can waive venue in personam, but you can never waive subject matter jurisdiction.
Well,
if I come to you and I say, "You got this ticket over here, and I think that judge in the court is a chump, so I'm going to be the judge for the case. Do you agree?" No. You can't give me the jurisdiction no matter what. Okay, go ahead.
Right. As the filing motion, now I understand that. I've seen a ton of case law which says a challenge to the jurisdiction can be raised at any time, even on appeal. But as to filing other types of motions, the Rule 12 of the Texas Rules of Civil Procedure sets out that those rules govern also in the Justice Court. And most of the rules in the Rules of Civil Procedure regarding the filing of motions say that, in most cases, they have to be filed at least 10 days before the hearing on the matter. Well, in my case, from the
you didn't get 10 days.
Right, the eviction hearing.
Oh, great.
So
move for continuance, lack of proper notice.
Okay.
Yeah, that'll work good.
It does. I mean, I got served with the summons and the citation.
Okay. Hang on, we're about to go to break.
Gotcha. Okay.
For some reason, I'm not hearing the bumper music as loud as I normally do. Okay, this is Randy Kelton, Deborah Stevens, Eddie Craig, Rule of Law Radio. Our call-in number, 512-646-1984. Robert, Mark, I see you there. We will get to you on the other side.
The Bible remains the most popular book in the world, yet countless readers are frustrated because they struggle to understand it. Some new translations try to help by simplifying the text, but in the process can compromise the profound meaning of the Scripture. Enter the Recovery Version. First, this new translation is extremely faithful and accurate, but the real story is the more than 9,000 explanatory footnotes. Difficult and profound passages are opened up in a marvelous way, providing an entrance into the riches of the Word beyond which you've ever experienced before. Bibles for America would like to give you a free recovery version simply for the asking. This comprehensive yet compact study Bible is yours just by calling us toll-free at 1-888-551-0102 or by ordering online at freestudybible.com. That's freestudybible.com.
You are listening to the Logos Radio Network, logosradionetwork.com.